We are on the air. I love being on the air. Don't you love being on the air?
Yeah, I was looking at the monitor thinking,
fun.
they're telling me we're going to be on the air 2 minutes and I'm talking to myself.
Well, at least...
no problem.
At least you sound like a lawyer even when you're not on the air.
No, you didn't see what I was
Welcome back. You can call us at 1-800-405-4222. That's how to get in. That's how to ask a legal question. And by the way, if you drop your remote and the channel changes, because I know you wouldn't do it voluntarily, we're City TV Channel 16 in Santa Monica, and if you're in Los Angeles, it's Channel 36, so that's how you come back.
Or for any place in the United States, you can watch us webcasting at la36.org.
Yep.
And
you can call us from Nome, Alaska.
So let me ask you this question. You own a local saloon in Santa Monica or any part in Southern California.
Okay.
And every time there's a drunk driving arrest within a block or two, they ask the driver of the car, "Where were you drinking?" And he
Where
says,
were you last drinking? That's on the form. It's a state law requirement.
So the guy says, "I've been drinking at Schmoozy's bar." Do you think?
Schmoozy.
So Schmoozy's bar, it says in Orange County, and it has 72 arrests for drunk driving in a year.
Wow.
Do you think that is reason for the police,
That's a lot.
Police, the city, the state to take action against the owner of the bar and maybe close him down?
Oh, yeah, it is actually.
That's sort of
well, we know the answer to that question. We've seen it. We've seen the state try to do that.
72 arrests in a year.
That's a lot. That's like many.
I may have been drinking at 50 other bars, but
that's 6 a month.
That's a lot. Drunk driving arrests.
That's too many. Absolutely too many.
So should we put the video up?
Yeah, we've got a video that we want to show everybody. There's a truck involved, and let's sit back and watch it.
Okay, let's watch it. There's a car.
That's a car. So far, it looks pretty peaceful.
So far, it looks like a cartoon. Boo. Oh, my.
Okay, what happened? Do you see any liability? Firstly, it doesn't look like...
Let's show it again, Wolf.
Let's look at it again. Maybe just that's the part. No, that's not the part. You never know.
Well, I'm looking at now. There's a car turning left. Oh!
Okay,
my goodness.
this looks like it's not a controlled intersection. It looks like it's not even in the United States. But let's place this in an intersection.
Well, I don't know where it is. But the car turning left in most jurisdictions in front of another car is at fault.
Yes.
So that the driver of the little car, which got squashed by the big green truck, is in California would be comparatively negligent for turning in front and violating the right of way.
Yeah. So let me add some facts maybe. The truck wants to go straight. The reason he veered to his right.
Well, I don't know why he veered to the right.
It looks to me, and let's assume that I'm right because here I am. He was trying to veer to his right in order to avoid the accident.
Oh, okay.
All right, and when he did that, he flipped and he fell directly on top of the car taking a left. The car taking the left, the person's now a quadriplegic. He's going to need $100,000, $200,000, $300,000 a year just to maintain himself. The truck driver has no injuries whatsoever.
So normally in California, in a normal quadriplegic case, the case is probably worth in a range of from $6 to $20 million. I'm talking just for lifetime care, young person, decent job, etc. Huge difference. So what happens if the truck was 100% at fault, then the driver of the car could recover the total amount.
Right. If
you're comparatively negligent, if I'm 90% comparatively negligent, and the jury awards $10 million, it gets reduced by 90%.
Right.
So
if the little car is 90% negligent, then he gets 10% of that recovery.
Yeah, but on the other hand, for actual medical bills and non-pain and suffering thing, the truck could be liable for 100% of that. So
that doesn't seem very fair, does it?
Well, nothing's fair in this world. So we got a call. Let's go to it.
Let's take David's call from North Hollywood. David?
Hi, how's it going?
Very well, David. How are you?
I'm doing well. I have a business question for you guys.
Okay.
Let's say, you perform a service for someone, you sell someone product for a considerable amount of money or in the thousands of dollars range.
You have to...
And you don't have them sign a receivable, a note saying that, they received this product and that they owe you the money. You just, have an invoice and you make invoices for it. What are your legal options against them if they don't pay up on you?
What kind of product are we selling?
Flowers.
Okay. And is it a one-time delivery of flowers, or is it like every week or month of flowers are going there?
Well, let's say it's a lot,
Okay.
all the time, once a week.
All right. So, depending on what and how much money you think's involved?
Probably like $15,000 to $20,000.
Okay. So, oral contracts are valid in California. The time to sue on an oral contract is 2 years. So you could file a suit in the LA Superior Court. This would probably be a limited jurisdiction case because it's for the amount of money, $20,000. So it can be done fairly quickly. And if you're believed and you have the invoices, they don't have to sign for it. If they get the product and they keep getting the product, they keep not paying you, you keep sending the invoice, they're liable for it. Now, if you're not believed that it happened, I never got the flowers, I don't know what it was, they were left on the wrong porch, etc., then you don't win. But if you're believed and you've got some kind of witnesses that support it, you can win on an oral promise. It doesn't have to be in writing.
Yeah, my partner's got a good point. It's a question of proof. If you have the recipient sign for the delivery when the flowers are delivered, then you've got a really good piece of proof to show a judge to demonstrate that the flowers were delivered and received by the person to whom they were delivered.
Well, who made the delivery? It was somebody else other than you?
No, it was someone the individual would come into the store and purchase the product. But also, that's the thing, that we have employees. Are employees allowed to, be witnesses? Are they credible?
Well, I don't know if they're credible or not, because credible means believable. But of course, anybody involved in the situation, you have other employees standing around seeing the people taking the flowers? Of course. You've got witnesses. It sounds like you got a case that you're going to win on. It sounds like a winnable situation.